I left home with $280 and one backpack after my father called me mentally unstable in front of the church. 8 years later, my family found me and suddenly needed me. The first text came at 2:13 a.m. Sweetheart, is this really you? 8 years of silence, and then my sister Emily, like nothing had happened. Like she was just picking up a conversation we'd paused mid-sentence instead of one she'd let die 8 years ago. I remembered exactly why the silence started. I remembered it in the kind of detail that doesn't fade even after nearly a decade. The detail you'd think time would sand down, except it doesn't, because your body keeps the receipt even when your mind tries to file it away. My father stood in front of our whole church and called me mentally unstable, said I stole a scholarship, said I ran from responsibility instead of facing it like an adult. 200 people nodded along. Nobody asked me for my side. The truth was simpler than any of that. I earned that scholarship. He just didn't want me to leave. I didn't answer Emily. I set the phone face down on the kitchen counter and stared at the wall instead. The way you stare at a wall when your brain hasn't caught up to what your eyes just read. It rang anyway. Mom. I let it ring 4 times before I picked up. Not because I was deciding whether to answer, because I needed those 4 rings to remember how to breathe normally. Emma? Honey? Why didn't you tell us where you were? I almost laughed. Not because it was funny, because it was the exact opposite of funny. Because the question assumed I owed them an itinerary, when the last thing they'd given me was a public excommunication. They spent 8 years making sure nobody looked for me, and now the silence was my fault. You know exactly where I was, I said. Silence on her end. Then, your grandmother wants to talk to you. By morning, my phone wouldn't stop. Cousins I hadn't spoken to since I was 19. Aunts who used to send birthday cards and then just stopped mid-decade, like a subscription that lapsed. An old neighbor who once told my mother she'd pray for me, like I was already lost. Already a cautionary tale whispered over coffee after Sunday service. 27 messages by 9 a.m. I counted them twice, sitting on my kitchen floor with my back against the cabinets, because counting felt like the only productive thing I could do with my hands. Every one of them said some version of the same 3 words. We need you. Not one of them said sorry. I opened the link Emily had sent, a local news story about my nonprofit, Second Draft Tutoring, free academic support for kids who couldn't afford it. Kids like I used to be, before a church youth group leader noticed I was doing algebra homework by streetlight because our apartment's power got shut off twice that winter. My name in the caption. My photo, front and center, smiling next to a banner I paid for out of my own pocket the first year, back when the whole operation ran out of a borrowed church basement 2 towns over from the one that had thrown me out. That's how they found me. Not through worry. Through a Google alert somebody had probably set up on my name 8 years ago and forgotten about, until it finally pinged. 8 years of nothing, and the moment my name showed up attached to something that looked successful, my phone turned into a group chat I never joined and couldn't leave. Emily called back 20 minutes later. Her voice was tight, nervous, not sorry. There's a difference. And I'd had 8 years to learn to hear it. Dad needs your help. Not, I'm sorry. Not, we were wrong. Dad needs your help. His church found out the scholarship story was fake, she said, the words tumbling out too fast, like she'd rehearsed them in the car. There's an inquiry. The elder board wants him to explain himself. Then, quieter, like she was hoping I wouldn't quite catch it. He needs you to sign something about the property. I gripped the phone tighter. My knuckles went white before my brain even processed why. What property? Grandpa's land. The old house. A pause, the kind that tells you someone's choosing their next words very carefully. Dad just needs your signature saying you won't contest how it's divided. It's just a formality. Emma, a formality. After 8 years of silence, the first real request my family made of me was a signature. There it was. Not forgiveness, leverage. I want to back up, because if I just tell you about the phone call, you won't understand why my hands started shaking before I even knew what I was shaking about. I grew up in Millhaven, a town small enough that everyone knew whose car was parked where on a Tuesday night. My father, Richard Calloway, was a deacon at Grace Fellowship, not the pastor, but close enough in influence that half the congregation ran their life decisions past him first. He had a way of talking that made rooms go quiet, not because he raised his voice, because he lowered it and people leaned in to catch what he said. And by the time they'd leaned in, they'd already halfway agreed with him. I was 17 when I applied for the Whitmore Foundation Scholarship, a full-ride academic scholarship for first-generation college students, merit-based, need-blind, funded by a family foundation that had nothing to do with our town or our church. I wrote 4 essays. I sat 2 rounds of interviews. I got the acceptance letter on a Tuesday in March, and I remember reading it 3 times standing in the school parking lot because I didn't trust myself to have read it right the first time. I brought the letter home expecting my parents to be proud. My father read it once, folded it back along its original creases, and set it on the kitchen table like it was something that needed to be dealt with rather than celebrated. You didn't discuss this with us, he said. I hadn't realized applying to college required a family vote. I still don't think it does. But in my father's house, anything that gave you a way out that he hadn't personally approved of was treated like a betrayal in progress. Here's what I didn't know yet. Sitting in that kitchen at 17, my father had, 4 years earlier, signed a document related to my late grandfather's estate, an education clause tucked into the property trust that gave any grandchild who used the family land for teaching purposes a right to claim a direct share of it. No family vote required. My father had signed off on that clause as executor. He'd known about it the entire time. And somewhere in the years after, he must have started doing the math on what it would mean if I ever became the kind of person, stable, credentialed, believable, who could actually walk into a courthouse and use it. I didn't know any of that then. All I knew was that my father seemed to need me to fail more than he needed me to succeed, and I couldn't understand why. And it was would take me the better part of a decade to find out. 3 weeks after the acceptance letter, my father stood up during the announcements portion of Sunday service, a segment normally reserved for potlucks and prayer requests, and told the congregation that I had, in his words, obtained this scholarship through means the family isn't comfortable discussing publicly, and that I was struggling with some mental health difficulties that made her prone to fabrication. 200 people, my mother sitting 3 rows back, staring at her hands, my sister Emily, 16 at the time, not looking at me at all. Nobody asked me for my side. Nobody asked the Whitmore Foundation for a verification letter, which, I checked later, they would have provided in about 4 business days. I left for college that August with $280 in cash, 1 backpack, and a phone number for a graduate teaching assistant named Patricia N. Camelu, who ran the peer support office and who, when I showed up in her doorway 3 days into orientation with nowhere to go over fall break, quietly arranged emergency housing without asking me to explain the whole story first. I built a life out of that beginning. It took years. It is not a straight line, and I'm not going to pretend it was, but by the time Emily's 2:13 a.m. text landed on my phone, I had a bachelor's degree, a master's in social work, a nonprofit with 4 full-time staff and 11 part-time tutors, and a photo in a local news article that apparently reached my family faster than any letter I could have written them. The first crack in my composure came 2 days after Emily's call, when my mother texted a photo of my father, not of him, but a screenshot of a document, blurry, half his thumb in frame. "This is what he's dealing with. Please just call your sister back." I zoomed in. It was a letter from Grace Fellowship's Elder Board, dated the week before, informing my father that his standing as deacon was under formal review pending clarification of statements made regarding a scholarship matter in my case. I told myself it was nothing to do with me directly, just fallout. I wasn't obligated to feel anything about consequences that were 8 years overdue. Then Emily sent a second message, and the thing that had been sitting quiet in my stomach for 2 days turned over. They found out because someone from the Whitmore Foundation reached out to the church directly, said they'd seen the article about your nonprofit and wanted to confirm you were the same Emma Calloway who'd been a scholarship recipient. The board asked Dad to explain what he'd said back then, and he couldn't. My hands weren't shaking yet. That came later. Right then, I just felt very still. The way you feel still right before something breaks. I called my old college roommate Dana, who still lived 2 states from Millhaven and had family that kept loose tabs on church gossip through her mother. "Emma, I don't want to scare you," Dana said, "but my mom mentioned your dad's been asking around about property lawyers, like actively, for weeks, before your family even reached out to you. Weeks before Emily's 2:13 a.m. text, before any of this had supposedly been discovered." I told myself maybe it was unrelated. Property law is common enough. People ask about it for all sorts of reasons. I didn't want to be the kind of person who saw conspiracy in every family interaction, even a family like mine. Then I got the second text from my mother 3 days later. "We just need this handled quickly. The board meets again in 10 days. Handled. Not resolved. Not made right. Handled like I was a liability being routed around, the same as I'd been 8 years earlier, just repackaged with more urgency this time. My stomach dropped the way it does on a plane losing altitude, and I sat down on my kitchen floor a second time. I tried to fix it the only way I knew how. I called Emily back and asked her calmly to just tell me the truth. All of it. What was actually happening. She wouldn't. She kept circling back to the same phrase. "It's complicated, Emma. Just trust me." I hung up more unsettled than before I'd called. 2 weeks earlier, I only pieced this together afterward, my father had gone to a local attorney named Gerald Voss to ask about cleaning up the property division before, in Gerald Voss's own later words to investigators, any family member with outside legal representation got involved. I didn't know this yet, but the pattern was already forming, and every attempted fix I made just kept bumping into the edges of it. I told myself the property thing was separate from the church thing. 2 different problems, coincidentally colliding. Then my mother sent a third message. This one longer, more pleading. The kind of message that reads calm on the surface and frantic underneath if you know how to read it. "Emma, your father is not well. This stress is affecting his heart. The doctor is concerned. Please, we just need the signature and everything else can be handled separately." I felt the ground tilt a little. Not because I believed the heart thing outright. I'd learned the hard way not to accept my father's crises at face value, but because that's exactly what a health scare is designed to do to you. It short-circuits your skepticism. It makes you feel like a monster for asking questions. I called Patricia N. Camelu, my old graduate mentor from college, the one who'd found me emergency housing 8 years earlier. She'd moved into hospital social work since then, and I trusted her read on manipulation tactics more than almost anyone's. "Emma," she said after I'd laid it all out, "I want you to notice something. In every message they've sent you, is there a single one that doesn't ask you for something?" I scrolled back through 2 weeks of texts while she waited on the line. There wasn't. Not one. "That's not a family reconnecting," Patricia said gently. "That's a family managing a liability. I'm not saying don't help your father if he's actually sick. I'm saying get independent confirmation before you do anything, especially before you sign anything." I tried one more time to fix it through the family channel. I asked my mother directly for the name of my father's cardiologist, so I could, if needed, speak with them myself about his condition. She never sent it. 3 days passed. I asked again. Nothing. That was the moment I stopped trying to solve this inside the family and started treating it like what it actually was, a legal situation wearing a family costume. I called Marcus Ferreira, an attorney I'd used for the nonprofits incorporation paperwork 3 years earlier. 11 years in estate law, meticulous almost to the point of being annoying about it, which was exactly what I needed. He picked up on the second ring, the way he always did. said. I read him the will language Emily had photographed and sent me weeks ago, word for word, my hands shaking just enough that I had to start the second paragraph twice. My grandfather's property trust has an education clause, I told him. Any grandchild using the land for teaching purposes can apply for a direct share. No vote required, no family consensus needed. That's what they're asking me to sign away. Marcus went quiet on the other end, the particular quiet of a lawyer who's already 3 steps ahead of you. Send me the photo. I want to see the actual clause, not the summary Emily gave you. I did. He called back 4 minutes later. This is real, Emma, and it's been sitting there this whole time. A pause. Do you currently use any part of that property for tutoring, teaching, anything along those lines? I told him about the church basement, the one 2 towns over, where second draft tutoring had run its very first sessions before we outgrew it and moved to a rented space. That basement sat on a smaller adjacent parcel that had been folded into my grandfather's original land trust decades ago, before I was even born, when the church had leased the space from my family for a token $1 a year. Marcus went very quiet again. That might be enough to qualify you under the clause. I need the original filing to be sure. Don't sign anything, he said. Let me pull the original documentation first. My father knew about that clause. He'd known for 8 years, maybe longer. If I ever looked stable, credible, believable, the kind of person a probate judge would take seriously, I could claim it anytime I wanted. So he'd made sure, years in advance, that nobody would believe me first. The church announcement wasn't cruelty for its own sake. It was insurance. That realization hit me somewhere between my collarbone and my stomach, a physical sensation I don't have better words for than the floor tilting sideways. 3 days later, Marcus called back. His voice was different this time. Careful. In the specific way people get careful right before they hand you something they know will hurt. Emma, I need you to see this in person. I sat across from him 20 minutes later in his office, a cramped space with more filing cabinets than furniture. He didn't say anything at first. He just slid a single folder across the desk and turned it to face me. There's a second document attached to the filing, he said, from 4 years ago. It has your father's signature on it. He didn't open it. He just watched my face as I reached for the folder. I opened it myself. It was a petition filed with the county probate court 4 years earlier, quietly, with no notice sent to me because I'd had no known address on record, to have the education clause voided for cause, on the grounds that the named beneficiary, me, was, for my father's sworn declaration, mentally incompetent to exercise sound judgment regarding legal or financial matters, as previously and publicly acknowledged within our religious community. He'd used the church announcement as legal evidence against me. The same lie he'd told 200 people 8 years ago, he'd resubmitted 4 years later as a sworn court filing, citing his own public statement as if it were independent corroboration of itself. Did it work? My voice came out steadier than I felt, which surprised both of us. No, Marcus said. The petition was denied. Probate courts require documented clinical evidence for a competency claim, not a church announcement. But Emma, he tried, and the fact that he tried 4 years ago tells us this wasn't a reaction to your nonprofit showing up in the news. He's been planning around this clause since before you even had a nonprofit. I sat there holding a folder that proved my father had spent 4 years, longer probably, engineering a legal reality where I'd never be believed enough to claim what was already mine. My hands were shaking now, fully, undeniably shaking, in a way I couldn't blame on caffeine or cold. What do? I asked, and it wasn't really a question so much as an exhale. You do what he was afraid you'd eventually be able to do, Marcus said. You get a formal competency evaluation on the record, voluntarily, on your terms from a neutral clinician, so that claim is dead permanently. Then we file for you to exercise the education clause. And separately, I think you need to talk to someone about that 4-year-old filing, because misrepresenting a sworn declaration to a probate court isn't just a family matter anymore. I found Dr. Helena Bright through Patricia's professional network, a licensed clinical psychologist, 19 years in forensic evaluation, the kind of credential that exists specifically so that judges don't have to take anyone's word for anything. I sat for 2 sessions of formal assessment, answering questions that felt invasive and clinical and honestly a little insulting given that I ran a 4-person nonprofit and had a master's degree. But I understood the strategy. You don't argue with a ghost. You bury it in paperwork so official that it can never rise again. Dr. Bright's written evaluation was 11 pages. The conclusion, on page 10, was 1 sentence. The evaluee demonstrates no clinical indicators consistent with impaired judgment or diminished competency in financial, legal, or personal decision-making domains. Marcus filed that alongside our petition to exercise the education clause. He also filed a formal complaint with the county clerk's office regarding the 4-year-old petition, flagging the sworn declaration my father had submitted as potentially fraudulent, given that it cited a public church statement as clinical corroboration when no actual clinical evidence existed or had ever been sought. That's when Detective Renata Ibarra got involved. 17 years with the county sheriff's department, the last 6 specifically in financial and elder fraud investigations, because a filed sworn declaration that misrepresents facts to a court isn't just a civil matter. Depending on intent, it can cross into perjury or fraud on the court. She called me on a Thursday. Her voice was flat and professional in a way that felt oddly like relief after weeks of family voices that were anything but. Ms. Calloway, I've reviewed the filing your attorney flagged. I want to ask you some questions about the original scholarship situation 8 years back and about what you know regarding your father's more recent legal activity concerning the property. I told her everything. The Whitmore Foundation letter, the church announcement, the 8 years of silence, the 2:13 a.m. text, the formality signature request, the heart attack pressure campaign that produced no cardiologist's name when I asked twice. She was quiet for a moment. Then, I want to be straightforward with you. A false sworn statement to a probate court is a serious matter on its own, but the pattern you're describing, using an unfounded incompetency claim to suppress a beneficiary's rights, timed specifically around asset value, that's something my unit takes very seriously. I'll need copies of everything. Texts, the original filing, your attorney's documentation. I sent her everything within the hour. I remember my hands were steady by then. Somewhere between Dr. Bright's 11 pages and Detective Ibarra's flat procedural voice, the shaking had stopped. The pressure from my family didn't stop, though. If anything, it got worse, because now they could sense, even without knowing the specifics, that something had shifted on my end. My mother called 4 times in one afternoon. I let 3 go to voicemail. On the 4th, I picked up. Emma, please, the board meets in 3 days. Your father needs this resolved before then. Why won't you just help him? I am helping him, I said. I'm helping him tell the truth for the first time in 8 years. That's not what I meant, and you know it. It's exactly what you meant, I said. You've never once asked me what actually happened. Not 8 years ago. Not now. You've only ever asked me what I could do for him. She didn't have an answer for that. The silence on her end stretched long enough that I almost thought she'd hung up. Then Emily texted me directly, bypassing the family group thread entirely. He's telling people you're trying to destroy him out of revenge. Please just call him and explain your side before the board meeting. Please, Em. Please, Em. The nickname nobody had used since I was a teenager, deployed now like a key that used to fit a lock that had long since been changed. I had 72 hours before the Elder Board's next scheduled review, and inside that same window, Detective Ibarra's investigation was moving toward a formal interview with my father, and Marcus's petition to exercise the education clause was scheduled for a probate hearing the following week. 3 systems, 3 clocks, all converging. I remember standing in my kitchen at 11 p.m., the same kitchen where the whole thing had started with a text I set face down on the counter, and thinking, it's this or nothing. There's no version of this where I wait quietly and it resolves itself. My hands found the counter edge and gripped it, knuckles pale under the kitchen light, the exact same posture as 3 weeks earlier when this all began. I called Marcus at 11:14 p.m. He answered, which told me something about how seriously he was taking this too. I need everything ready before the board meets, I said, not to punish him in front of the church, to make sure nobody can pretend this is ambiguous anymore. I can have a summary letter to the board's legal counsel by Friday morning, Marcus said. Factual only. The original Whitmore verification, the 4-year-old filing, Dr. Bright's evaluation, no editorializing. The facts do the work. Do it, I said. The board received Marcus's letter on Friday morning, addressed not to my father, not to the congregation, but to the board's own retained legal counsel. A deliberate choice, Marcus explained, so the information reached them through a channel that couldn't be dismissed as a family grudge. The letter contained 3 things: a verification letter from the Whitmore Foundation, confirming my scholarship had been awarded on merit with no irregularities, ever, in their program's history involving my case. A copy of the 4-year-old probate filing in which my father had cited his own church announcement as sworn evidence of my incompetency, and Dr. Bright's clinical evaluation stating unambiguously that no such incompetency existed, then or now. The board convened an emergency session that same afternoon, ahead of its originally scheduled date. I wasn't there. I heard about it secondhand, through my mother, whose tone on the phone that evening had changed entirely. No longer pleading, now hollowed out, like someone watching a structure they'd built their whole identity around come apart in real time. They suspended him, she said, pending a full review. They said, her voice caught, they said the filing showed a pattern of dishonesty they couldn't reconcile with his position. I didn't feel triumphant. I want to be honest about that because I think people expect this part to feel like winning, and it didn't. It felt like watching a wall finally fall down after years of being told the wall wasn't there. Did you know? I asked her. About the filing, 4 years ago. Long pause. I knew he'd talked to a lawyer. I didn't ask what for. I didn't want to know. That was, in its own way, its own kind of answer. Detective Ibarra's investigation moved in parallel. She interviewed my father formally the following week. I wasn't in the room, obviously, but she called me afterward with an update, professional and clipped, giving me only what she was permitted to share. He's retained his own attorney now, she said. The county prosecutor's office is reviewing whether the 4-year-old filing constitutes a fraudulent statement to the court. That determination isn't mine to make, but I can tell you the evidence trail is well documented thanks to your attorney's filing practices. What happens to him? I asked, and I noticed, even as I asked it, that some small part of me still braced for the answer the way you brace for news about someone you used to love, even after everything. That's up to the prosecutor, and eventually, the court, she said. What I can tell you is that this kind of case, fabricating grounds to suppress an heir's rights, carries real consequences when it's this well documented. It won't be quiet. The probate hearing for the education clause happened 9 days later. Marcus handled almost all of it. I sat beside him at a long table in a courtroom smaller and plainer than I'd imagined. Fluorescent lighting, a judge who looked bored until she started reading the actual documents, at which point she stopped looking bored entirely. The clause was upheld. My use of the leased parcel for second draft tutoring's original sessions qualified under the plain language of the trust, and the 4-year-old attempt to void the clause was noted in the record as based on an unsubstantiated competency claim, now formally contradicted by Dr. Bright's evaluation. I didn't get the whole property. That was never really the point, and I want to be clear about that, because I think stories like this one get flattened into, she won everything, and that's not what happened, and it's not what I wanted. I got what the clause entitled me to, a direct share, tied specifically to the educational use. use, administered separately from the rest of the family's division of the estate. Enough to put a down payment on a permanent building for the nonprofit. Not enough, and never intended to be enough, to make me rich or make anyone else poor. What I actually got was smaller and larger than money. I got a signed court record stating, in plain legal language, that I had never been incompetent, unstable, or fabricating anything. The exact opposite of what 200 people had been told to believe about me 8 years earlier, now sitting in a public docket that anyone could pull if they ever doubted it again. My father wasn't in the courtroom. His attorney appeared on his behalf. I heard later that the county prosecutor's office ultimately charged him with a single count related to the false sworn declaration, a plea agreement in the end, rather than a trial, resulting in probation and a permanent bar from serving in any fiduciary or estate executor role in the county going forward. Grace Fellowship's board did not reinstate him. He resigned from membership entirely 3 weeks after the suspension, before they could formally vote him out. I felt something when I heard that. Not joy. Something quieter and heavier, like putting down a bag you'd been carrying so long you'd forgotten your shoulder was supposed to feel different without it. It's been 8 months since the hearing. My mother and I talk sometimes now, carefully, in the way you talk to someone across a bridge that's been rebuilt, but that you still test with your weight before fully trusting it. She's not living with my father anymore. She hasn't said much about why, and I haven't pushed. Some renovations happen slower than others, and some walls come down in private, without an audience of 200 people watching. Emily and I are not close. I don't think we will be. Not the way sisters in movies end up close after everything gets resolved. But she sent me a message a few months back, no ask attached to it, for the first time in 8 years, that just said, I should have asked you what happened back then. I didn't. I'm sorry it took this long for me to say that. I read it 3 times, the same way I'd read the Whitmore acceptance letter in a parking lot at 17, checking whether I'd read it right. I wrote back, thank you for saying it. That's all. It felt true, and it felt like enough, and I've learned not to manufacture more feeling than actually exists just because a scene calls for it. Second draft tutoring has its own building now. The down payment from the education clause covered most of it. Grant funding covered the rest. 14 tutors. 60 kids on our roster this term. Most of them doing homework somewhere warmer and better lit than a streetlight lit apartment with the power shut off. Patricia and Kemalu sits on our advisory board now. Dr. Bright, of all people, referred us 2 clinical interns last spring. I think about the version of me that stood in a school parking lot at 17 with an acceptance letter I couldn't stop rereading, and the version of me that stood in the same kind of stillness 8 years later holding a court filing that proved my father had spent 4 years engineering my disbelief in advance. Both times, the shaking eventually stopped. Both times, it stopped because I stopped waiting for someone else to hand me the truth and started building the paper trail myself. We spent 8 years making sure nobody would believe me first. It turns out that's not the same as making sure nobody ever would.